Morning. This is the House Committee on Government Operations and Military Affairs. It's Groundhog Day, Thursday, February 2nd. Happy Groundhog Day, everybody. We are here this morning to hear the first pass of a variety of different elections-related policy language that I've been working on with some of the Secretary of State's office, suggestions from some other stakeholders. And we're here first with Legislative Council, and Tim's going to walk us through the language. So thanks for being here.
Very welcome. Good morning, everybody. My name is Tim Devlin, for the record, Legislative Council. And I will be providing a line-by-line walkthrough of today's committee bill, which will identify as 23-0705. Just starting from the top, and actually feel free to ask me to slow down, whatever folks like. So we'll start with a statement of purpose of the bill as introduced. There's 7 parts essentially to this bill, with more sections than that. This bill proposes to prohibit losing primary candidates from running in general elections, update the independent candidate filing deadline, permit political parties to accept unlimited contributions from candidates, require the reporting of town and county committee members after the biennial reorganization of the state committee of a party, prohibit candidates from receiving cross nominations from multiple political parties, permit candidates to file demographic information, and to require registration for write-in candidates. We'll move on to actual sections. The first part is what is kind of a term of art, a sore loser law. Section 1 modifies Title 17 VSA, Section 2381, subsection C. And just for orienting purposes in the statutes, this is in a subchapter of the nominations chapter, subchapter nomination by party committee. The modified language adds subsection C. In no event may a candidate who loses a major party be nominated to appear on the general election ballot pursuant to this subchapter by a committee of any party other than the party of which the candidate appeared on the primary ballot. This is phrased so that 1, if a candidate loses a primary, they cannot run again in the general election. And 2, if a candidate wins a primary, their own party would not be precluded from nominating that candidate.
Can you say that again? Yeah, that just didn't make sense.
Sure, not a problem. Would you like me to read the language and then my annotation, or?
I would like your termination, your terms.
Your interpretation. It was just that bad.
We're not Great job. I'm happy to redress that. So this phrasing, for a matter of kind of syntax, has the purpose of 1, if a candidate loses a primary, they cannot run again in the general election. And also, we phrased it in this way so that if a candidate wins a primary, their party would not be precluded from nominating that candidate. So they win, the party goes in and nominates them as for regular operations.
So Tim, I'm going to just because this is really about clarifying what this means on the page, I'm going to give you an example. So if you run in a major party primary, so candidate runs in the Republican primary, loses, can't file as an independent and appear on the general election ballot unless, so this is the exception, if the Republican Party to fill a vacancy that arises. So let's say the winner of the primary, candidate Y, drops out, passes away, any of the ways that there could be a vacancy after the primary, the party could nominate the second place person, but that's really the only way that a person who loses a major party primary could get on the ballot. Am I interpreting that right?
Absolutely correct.
That's the way I thought.
So this is all prior to the general election, has nothing to do with after the general election. That was my
Correct.
misunderstanding. Thank you.
Representative Chase.
I thought I heard if a candidate wins the primary, then the party could nominate them.
Yes, So
Right.
candidate A wins the Republican primary, then their party goes on to put them on the general election ballot for the Republican Party. And I might be misunderstanding the point you.
I feel like if somebody won the primary, then they wouldn't need to be nominated to be on the ballot anyway.
Right.
Right.
Am I missing some nuance of statute here?
Tim, this doesn't change anything about if a candidate wins a major party primary, they're going to the general election. They're going to be
Correct. Yes.
This doesn't change anything about that.
It just means the party could nominate them also.
Well, the party automatically does that. Yeah, it automatically happens that if you win the major party primary, you are that candidate's candidate for that office on the general. We're going to have the elections division director come in and talk about the mechanics of how that actually works. I might put a pin in that for when we have Director Senning come up.
You know, he's sitting there.
Yeah. Oh, yeah. No. I'm just the people at home, setting expectations, and also flagging for Will that he is going to have to answer provide a little more color on the mechanics of that. Any other clarifying questions? I want to try to, while Tim's doing the walkthrough, keep the clarifying questions and talk about the context and the why as we get into it.
Moving on to section 2. This modifies Title 17 VSA, section 2401. And for context, this is under Title 17 elections, chapter 49 nominations and subchapter of 3 for independent candidates. And this adds a new section B after creating a subsection A. The new language, and would you like me to read A and then B, or just kind of go into the new language here? Happy to do either.
I think you can just go into the new language. That's fine.
Starting on line 9 there. Subsection B, a candidate who loses a major party primary for any office may not appear on the general election ballot as an independent candidate for the same office for which the candidate lost in the primary election. This language prevents a losing candidate from running as an independent in the general election, in addition to preventing them from running for another party as proposed above.
Representative Hanko.
Thank you. I just have a clarifying question about a committee bill because I haven't done very many of them in my experience here. Where did all this language come from and how did it get here before we're here listening about it?
Yeah, so I am presenting this. I've worked on it with a number of folks, and I'm presenting it as a candidate for the committee to take up. So,
okay, because this sounds like another bill that we have on our wall.
I actually saw that there are a couple of bills that have recently come to us where these are not unique ideas. Some of these are ideas that have been floated for decades. And we're actually going to have some of the sponsors of those bills hopefully come in either today or the next time we take some testimony on some of these issues next week because of that exact thing. So I think I like the fact that actually it's reinforcing some of the things I've been working on, that we have some of those bills introduced, but you are not wrong in that observation. Representative Hooper.
A foundational question. Since the parties are sort of separate entities from, I mean, they're running their own game here, have their own rules to some degree. And because of that action, we're telling an individual citizen that they cannot run for subsequent election to something. I assume this passes constitutional muster.
It does. There are other states which have sore loser laws in the books. They have been challenged in federal courts and have been upheld.
But our state constitution is somewhat more
Sure. I can certainly provide you with legal analysis, maybe at a later point.
I'm just
Filling in you.
asking for your opinion.
Sure. I'm not sure if there has been a iteration of this in the past, which presented opportunity for the courts to weigh in on this. It may be an issue of first impression, where the courts haven't, because this hasn't come into existence yet, that hasn't really been litigated. That being said, I look to, when we perform legal analysis of certain ideas that come up, we look to analogs in different states to see how the issues that occurred there were kind of analyzed by courts, and certain fundamental issues around rights of association, typically with political parties, as where my mind goes, or maybe due process rights in the 14th, or their parallels in state constitutions, how the courts kind of weigh in on those. But from our office's initial analysis, this passes muster. If you would like, we can look into it more and provide you something on that point. Okay.
So would it be fair to say that section 1 says if you lose a major party primary, you can't be nominated by another party? Section 2 is about if you lose a major party primary, you can't be running as an independent.
Correct.
Any other clarifying questions on sections 1 or 2? All right, I think we're ready to keep moving. Thanks.
Move on to the next part of the bill, which concerns independent candidate filing deadlines. Section 3 amends Title 17 VSA, Section 2402, subsection D in particular. And this also is in context of elections, the nominations, then independent candidates. The D1, and then we'll kind of skip into a subdivision of it. Starting on line 14, D1, a statement of nomination and a complete and signed consent form shall be filed. In the case of any other independent candidate, not earlier than the fourth Monday in April and not later than 5 p.m. on the fourth Tuesday after the first Monday in May, preceding the preliminary election prescribed by section 351 of this chapter, and not later than 5 p.m. of the 62nd day prior to the day of the special election. These modifications, including the seemingly perhaps odd 62nd day prior language, bring the independent candidates in line with primary election deadlines, specifically those found elsewhere in 17 VSA 2356.
Representative Henke.
So just to make this perfectly clear, instead of having the whole summer to think about it, an independent candidate now has to file basically at the same time as a major party candidate.
Any other questions about section 3? Representative Waters Evans.
Thank you. So the section where you say you can't run for an independent candidate for the same office which you lost in the primary election, isn't that saying the same thing as that line 17 where it says you have to file on that same day? Isn't that two ways of achieving the same goal?
The filing did, well, no, if somebody never ran and lost in a major primary, they could still run as independent if they never lost a primary, that is, if I'm understanding
Okay,
your point.
I think
It may
so.
not be.
Yeah.
I think what I'm hearing is that somebody could submit not a ballot, whatever, with the signatures
Yeah.
as either an independent or as a party candidate. And then if they lose the primary, they could say, oh, well, I'm going to throw that one out and go with the independent. So this is saying that they would have to have that in at the same time anyway.
So you have to choose one or the other.
Yeah.
Yeah, so we'll talk a little bit about the way it works today. We did a little bit of that table setting before, but we've been doing a lot of things since we did our run through of the elections timeline. But I think it'll come into pretty sharp focus The idea here is that the two things work together. So if any candidate who wants to appear on the ballot has to file at the same time, you have to choose at that time, am I running in a major party primary or am I filing as an independent? And then if you choose to run as a major party candidate and you lose, you can't then afterward file as an independent or be nominated by another major party if all three of these sections became law.
Okay.
Thank you.
Any other, yeah, go ahead.
Just to put a fine point on what I said before, it's the independent candidate part that bothers me a little bit here from a part in a party process. Effectively, you're obliged to follow the party process rules to some degree. But if you're coming in as an independent, we're basically saying that's not, well, clearly saying that's not an option. Once you've gone through door A, you can't come back out and go through door B.
So that's what the words on the page say. I want to save debate about it for now until later, because I want to make sure that folks understand what's being presented. I will make sure there's ample time for us to discuss all of this, and not on one, but probably multiple days if we're going to move any of this language forward. So thanks everybody for their patience during the first walkthrough of a bunch of pieces. So go ahead, Tim. Thank you.
Okay. I'll move on now to page 3 and the next part, which concerns campaign finance limits for statewide candidates. Section 4 amends 17 VSA 2341 subsection A. And this, I'll skip down to the new language. A political party may accept unlimited contributions from a candidate. Or they were limited, as you can see above, to $60,000. And there's not too much to expand on this one, I think, but.
So we're going to hear more about this. But I will just say for context that there's a bit of a lack of transparency right now, because if you're a federal candidate, you can contribute to your political party, have coordinated campaigns, and all of those dollars are tracked. You know who those campaign contributions came from. And there are really hard limits on statewide candidates doing the exact same thing. So this aligns statewide candidates, Secretary of State, Treasurer, Governor, et cetera, with the federal candidates for Congress and U.S. Senator, is my understanding. Is that a fair statement, Tim?
I would have to defer to Director Setting on that.
Okay. Well, we'll hear more about that. So put a pin in that. But any questions about the words on the page? Please continue.
Okay. Moving down to the next part, biennial committee reorganization reporting. Section 5 amends Title 17 VSA, Section 2313, which is under elections, political parties, then finally certificate of organization. This adds a new subsection, reordering what was previously F, pushing that down to G, inserting new language for subsection F, which reads, starting on line 18, at the same time of filing the certificate of organization, the chair and secretary shall file with the Secretary of State a single machine-readable electronic document containing a list of names and addresses of the town and county committee members from those towns and counties that have organized pursuant to this chapter.
So what's a machine-readable electronic document?
That language is borrowed from some of the campaign finance reporting language, something that facilitates the Secretary of State's office essentially to, if not enter digitally, then just take a form that's scannable and accelerate the intake of information.
So again, it's one form. Oh, okay, thanks.
And so a spreadsheet, essentially. So the idea here is that when the parties reorganize every 2 years. So that's the context of where this would fit in, is in the statutes that govern major party reorganization. Am I reading that right?
Yes. The first in the subchapter is 2301, which is the organization of major political parties, which requires a major political party to organize biannually. And then there are various other requirements entailing that organization. And this is just the new element introducing when it is reorganized, information regarding essentially who's in charge at the local and county level is communicated to the Secretary of State's office.
I think it would be useful for the committee to hear from Will just about how the reorganization process is sort of the relationship the Secretary of State's office has to the major parties in terms of the biennial reorganizations. For the uninitiated, every major party reorganizes at the town, county, and state level every 2 years, chooses its officers, but it starts with caucuses at the local level. And this is about having a very succinct, easy for the Secretary of State's office way to report who all of the officers and members of the committees are at the local, county, and state level after the reorganization every 2 years. Any questions about section 5? We'll have much more conversation about all of these. Just want to be okay, great. Thanks very much, Tim.
Okay. Moving on to page 4, I believe, yep. Next section or next part is cross nominations. Section 6 amends Title 17 VSA Section 2472, subsection B, subdivision 5, that subdivision 5. And this is under conduct of elections and balancing the contents. A candidate may not, a candidate may only list a single party next to the candidate's name on the general election ballot as selected by the candidate pursuant to section 2474. And I'd also like to note that later on in the bill, we add a subsection 6, but that's regarding write-ins. I just want to I'll put a pin in that one. So if this looks familiar later on, that's what that is, non-error. Any questions about this cross nomination, or what's also sometimes referred to fusion voting as well?
Representative Hango.
I guess right now, in terms of a candidate who didn't voluntarily solicit 2 nominations, one from each of the major parties, but got enough votes in the primary, where does that leave that person? The general population voted for them on a different ballot, actually wrote in their names.
This language would limit the person to essentially picking one, I believe.
And it would be up to the candidate to pick, not the number of votes that they received from each?
Yes, I believe it'd be the prerogative of the candidate.
And do we ask now where this came from, this idea?
This is an idea that I have supported for a long time and that I included in this bill for discussion by the committee.
So clarifying off of the question Representative Hango just posed, so that designation on the general election ballot for said candidate would be how they filed, correct? For the primary. When they filed their paperwork, they filed as a Democrat or Republican, they would move on to the general there, but if they got what were previous to this would be the necessary write-ins to have the hybrid, that wouldn't happen. I think I'm asking this question poorly.
I apologize, I'm not quite following, but as far as the mechanics of it again.
However you file for the primary is how your name would exist on the general election. If there was no candidate on the other party and you got the write-ins, you would not wind up having like you wouldn't be listed as a Republican and a Democrat on the general.
If you were to wind up winning, I think no matter if it was by election or caucus or write-in being nominated, it would still just be, the candidate would just choose which one. And I may.
Here's the next.
Oh, okay, okay. I'm jumping ahead. Never mind, never mind.
So I think two things that I'll say is great questions. Tim's probably not the most equipped person to answer them. I think there's another person in the room that can help us understand this better. The next section. So
I will throttle back on that.
I think I really want the committee to deeply understand each one of these sections, but we're just doing the first walkthrough of a bill that I plan on us taking time on over the next few weeks while we're doing other things. So, so I want everybody to just know that we're gonna have plenty of time to learn and understand, and we're gonna hear from lots of folks. Representative Hooper.
I assume this fence constraint exists only until after the election. And then if I get elected as a Democrat and maybe successful in getting me to caucus with the Republicans when I sit here, this does not bar anything in that regard.
No, this pertains only to elections. If you were to change party allegiances or something, this doesn't speak to that.
Tim, as I understand it, there's nothing in our law that says the major party that you have printed as being nominated as that party on the ballot requires you to caucus with that party when you are elected to the General Assembly, for instance. There's no connection or law about it.
Not that I'm aware of. I could certainly look into it more. I don't feel completely confident to tell you off the top of my head, but not that I'm aware of.
Okay. Representative Cooper.
Was your question if it's the law that you have to attend caucuses or something?
I
can tell you that's not a law.
Well, I'm sure we're
Not yet.
just to be perfectly clear, there is no proposal on the table to enforce Representative Hooper's attendance at any state caucus attendance.
I thought there was a Hooper caucus yesterday.
Tim, I'm sorry. After yesterday, I feel like we got punchy and I like it. I wanted us to have some fun here in the House Gov.Ops and Military Affairs. Please continue.
Next section, section 7 on line 10, amends Title 17 VSA, section 24, section 4. And this is choice of parties. Subsection or A1 removes may, and I'll just read it through, sorry. A person nominated by any means for the same office by more than one political party shall elect not later than 5 p.m. on the 10th day following the primary election, the party in which the nominee will be a candidate. The nominee shall notify in writing the Secretary of State of such choice by that deadline, and only the party that the nominee so elects shall be printed on the the nominee's name on the ballot. Excuse me. So we can see we change may to shall on line 13. We also remove some language breaking across lines 5 and 16. I believe for some practical reasons that I'll defer to the Secretary of State's office to speak to later if that need be explored. Moving on to subdivision 2. If the nominee does not notify the Secretary of State or the town clerk of the nominee's choice of party, the secretary shall print on the ballot next to the nominee's name of the major political party for which the nominee had the nominee's name printed on the ballot in the primary. And so kind of jumping back up, of page 4 there, there is some gender neutral language introduced. Then moving down, we remove various subsections, really kind of condensing it into just the first being the only directive left, which is the major political party for which the nominee It had the nominee's name printed on the ballot primary. Further,
So Tim, just a quick question from Representative Hayes.
yes,
This is just a logistical question. The stricken out, is that a word? Language, is a previous version of this draft. It's not current law.
it is current law.
It
That
is
is
current law.
proposed to be removed.
So Tim, the two things happening here are basically that if a person is nominated by two major parties, they first can choose which party they want printed on the ballot. Do all the other things that we talked about this topic in the bill. So the first thing is they can choose which one of those two nominations to accept, either the one that was printed, so they filed as a candidate for the Democratic Party, they won the write-ins on the Republican ballot, they have a choice. So if they won both primaries, one as a write-in, one as a filing, they have a choice. But if they don't choose, it defaults to the one they filed on.
Yes.
Thank you for answering the meandering question before.
And it's when trying to turn like a simple idea into law can sometimes be, a little like. All right, Tim, thank you. Any other clarifying questions on that section? Representative Waters, Evans?
I hate to say this, but I'm very sorry, but so when in line 16, you remove town clerk, so should it not be removed in lines 19 and 20? Where it says the Secretary of State or the town clerk of the nominee's choice of party?
Is at the bottom of,
Page 4,
correct?
yeah. Since you removed the town clerk earlier.
Oh, yeah.
That may be the case. Yeah, it seems like.
Sorry, guys, this is your life now.
I'm seeing some nods.
Yeah.
I think, I agree. So if we have this language in a future draft, we'll,
And I've made a note of that. Thank you.
thanks. I think we should put a notice for all witnesses that we have a copy editor on the
Yeah.
committee.
One.
It will be very helpful.
Donahue shaping up. It's a compliment.
Language-
No, totally, yeah.
Any other questions or edits for this section? Please continue.
Okay, moving on to the next part, candidate demographic information. Section A modifies Title 17 VSA, Section 2359, which pertains to notification to the Secretary of State. This is in primary elections. And I will read beginning on line 7. Within 3 days after the last day for filing petitions, all town and county clerks who have received petitions shall file with the Secretary of State a list containing the name, gender, age, race, or ethnicity, mailing address, and email address of all candidates, to the extent this information is provided by candidates, the office for which the candidates have filed, and whether each candidate has submitted a sufficient number of valid signatures to comply with the requirements under Section 2355 of this title. The town and county clerk shall also notify the Secretary of State of any petitions found not to conform with the requirements of this chapter and return to a candidate under Section 2358 of this title, and shall notify the Secretary of State of the status of each of such petitions no later than 2 days after the last day of filing supplementary petitions. And in some, this is voluntary proffering of it, demographic and some other kind of contact information by candidates that would then be relayed to the Secretary of State. This is for primary elections.
Representative Chase.
For publishing or for the Secretary of State use?
Secretary of State's use. I would defer to the next witness as to how they treat that
They would
data.
do it.
And we may want to dig into putting that very specific language in around how this data would be aggregated. But Tim, there's nothing in here that would require a candidate to report this demographic data.
That's correct.
So this is the kind of, we'll take some testimony. I know Representative Bloomley has been working on this issue, and I asked if it was okay if I kind of got ahead of her and incorporated this into our first pass, but there's probably there may be a bill in the works on this, because the idea is a lot of times we'll get questions of like, how many women are running for office, or how many people, like how diverse was the number of candidates this year? And that data doesn't really exist, and it would be much better for folks who are trying to get a sense of, members of this body, for instance, to have that self-reported by the members than it would be to sort of infer and make guesses. So that's kind of the idea, but we're going to hear some testimony about the origins of the collection of the demographic data, but there are a few different organizations that were interested in this, and I included it, but this one isn't one that came from me. Representative Hanga.
No, thanks. I'll make a comment when we have those people in.
The next section, I think more directly speaks to your question. This has to do with the modification of what's required to be put into a consented candidate form. Section 9 modifies Title 17 VSA, Section 2361, subsection B. Reading it aloud, starting on line 20, subsection B1. The consent shall file forth the candidate's name as the candidate wishes to have it printed on the ballot, the candidate's gender, age, race, or ethnicity, town of residence, correct mailing address, and email address. And then an affirmative statement which reads, a candidate who does not provide any such information may still appear on the ballot if all other requirements are met.
Is this just making it explicit that you don't have to provide the demographic data?
Yes, that second sentence is.
Still valid.
Yeah. So section 9 pertains to what the candidate writes down and then on the form, and then the previous section 8 pertains to the communicating the information to the Secretaries of State's office. So the two kind of work together.
Great. I will note that I am very interested to hear what the Vermont clerks have to say. And I know Carol Dawes is in our waiting room, and I appreciate her being here, listening to the walkthrough.
Section 10, this pertains to town meetings. Sorry, this is under local elections, town meetings and local elections in general. Section 10 amends Title 17 VSA, Section 2665, the notification to Secretary of State. Beginning on line 7, it reads, the town clerk shall file with the Secretary of State a list containing the name, gender, age, race, or ethnicity, street addresses, and email addresses to the extent the information is provided by the candidate, and the end date of the term of office of each select board member, city councilor, village trustee, and mayor elected. The town clerk shall not be required to ask the candidate for demographic, I think I should say information, if it is not provided in that form.
So what does that mean about, does the town clerk provide the consent form, or is it a universal consent form and they just didn't provide it to the town clerk?
I believe the consent form is uniform across various types of elections, and that it, depending on the race or the nature of the office, they can be delivered to the clerk in some instances, or directly to the Secretary of State, perhaps. And so this is following the same kind of reasoning as the previous two sections of communicating the information to the Secretary of State's office. But this section tells coming from the town clerks.
So section 10, similar to the idea of the previous two sections, we're collecting the demographic data for these local offices, but the town clerks are not required to ask the candidates. It's just on the form. If they collect it on the form, they send that along with all of the other data that they're sending to the Secretary of State already.
Correct.
Then Morgan.
So just to be clear, so it's resonating throughout that it's all strictly voluntary. Every step of the way is what we're saying.
Right. So the form has a box for ethnicity, gender, age, data. But if you leave it blank,
It's up to you.
it doesn't have any impact on your name appearing on the ballot. Just means that box is blank.
Choose not to.
Okay.
And I know this may not be the time, but just to interject that if you don't have all the data from all the candidates, your data is going to be skewed if you're trying to compile data on ethnicity and whatever else it is, so.
Yeah, I think we'll have folks come in and talk about this. I think the idea is that most people, if it's on there, they'll default to filling it out and have any issue with it being aggregated. And that folks who have any concern about it will leave it blank. And so that there probably will be we would assume there would be a high return rate, but we'll talk about sort of how that works and at what point is it not useful to have it if you only get, half of the people reporting. I think that's a great question that we should dig into. Anybody else? Questions on words on the page for section 10? All right, let's continue.
Okay. The next part regards write-in candidate registration. Section 11 will modify Title 17 VSA, Section 2370. And this is in particular to primary elections in write-in candidates. Starting at line 18, a new subsection is inserted above the previously existing language, and it reads as follows. In order to have votes recorded for write-in candidates under Section 2587 of this title, not later than 5 p.m. on the second Friday preceding the primary election, a write-in candidate for any state or federal office shall file with the Secretary of State a form consenting to candidacy for office as set forth in subsection 2361B of this title. The Secretary of State shall notify the town clerks of any filings made in accordance with the subsection no later than the Friday before the election. And I can pause there and kind of continue.
Tim, this is an entirely new section. So right now, if folks are written in, there's no obligation to file anything about a write-in campaign. Current law, right? I'm trying to get a sense for the context of what this is changing.
Sure. Right now, and again, I would probably defer to Director Senning, who will be following me for a more in-depth analysis of this. Right now, I believe write-in candidates, they just can be written in without really any sort of prior to election notice to clerks or Secretary of State as to who they will be. Other people often write them in. As far as I don't think I am in a position to speak to any policy advantages or detriments that really be accompanying this change, but this would essentially require registration of those, or really for if you want to have your votes as a write-in candidate counted, then you would have to make yourself known essentially.
So that's an important thing to make really clear is the words "in order to have votes recorded." So that means you could have somebody have a write-in campaign, and if they had not filed, then those votes just wouldn't even count the way this is drafted today.
Yes, I'd agree with that.
Interesting. Representative Chase.
And I assume you helped draft H-149 with Pat Brennan and from the Colchester delegation, right?
Can't speak to that, but yeah.
Representative Brennan will be here at 10:45 because I saw that bill come through and I was like, this is perfect. We have, there's a.
It sounds very similar, and that was a request from our town clerk to preclude the votes for Mickey Mouse and Donald Duck and other candidates that didn't file.
This, part of the reason I'm asking questions as if I've never seen this before is because I've never really seen this before. I know that this has been talked about a lot amongst clerks, and we're going to hear from them and from the sponsor of Age 149 this morning. So yes, this is one of those things that I think could make it a lot easier to know who's really a write-in candidate and who is just somebody who didn't like any of the candidates on the ballot and is writing in Donald Duck or their own name, et cetera.
And there is additional new language in this subsection as well, in this section as well. On line 4, starting on, what page are we on now? 8, we see the addition under subsection B of number 1. I'll just start with B. Line 4, a write-in candidate shall not qualify as a primary winner unless the candidate has complied with subsection A of this section and other qualifications, just to kind of round out. Continuing to the next section, section 12, which modifies Title 17 VSA.
Before you continue,
Yes.
sorry to interrupt.
No, of course.
We heard from Representative Shy on the bill number, which I cannot remember,
Yeah.
H97. On line 7, the requirement to receive at least 1/2 the number of votes as the number of signatures required. That is a section I want to just flag that we might want to take a look at. The committee might want to look at bringing H97's language of raising that to the total number of signatures required on, as opposed to 1/2, as a potential future discussion.
Made a note of that. Thank you. The next section, 12, amends Title 17 VSA, section 2472 B6. And as I noted previously, above in the section regarding cross nominations, we had added a subsection 5 to this. So this section is being amended in 2 different places in the bill, just for clarity's sake. Subsection 6 reads as follows, starting on line 17. In order to have votes counted for a write-in candidate under section 2587 of this title, no later than 5 p.m. on the second Friday preceding the general election, a write-in candidate for any state or federal office shall file with the Secretary of State a form consenting to candidacy for offices set forth in subsection 2361B of this title. The Secretary of State shall notify the town clerk of any filings made in accordance with the subsection no later than the Friday before the election.
Just to clarify, so currently there is no filing for a write-in candidate. So this is requiring a filing, and it has to be the second Friday before the primary.
This section, let's see, we have preceding, second Friday preceding the general election. We have, let me double check the previous section 11.
That was section 11, and then section 12 says the same thing before the general election. So these are totally new in the statute, these requirements.
Yes. Section, no, we're good. Section 13 amends Title 17 VSA, Section 2587, subsection E in particular, and disregard state elections. E1 reads as follows: except as provided in the subsection, in case of write-in votes, the act of writing in the name of a candidate or pasting a label containing a candidate's name upon the ballot without other indications of the voter's intent shall constitute a vote for that candidate even though the voter did not fill in the square or oval of the name. New language being added under new subsection 2A. A vote for a write-in candidate shall be counted as a generic write-in vote unless the write-in candidate filed a consent of candidate form with the Secretary of State in accordance with the section 2370 of this title for the primary election as subsection 2472B of this title for the general election. The consent form shall set forth the name of the candidate, the name of the office for which the candidate consents to be a candidate, the candidate's town of residence, and the candidate's correct mailing address. The clerk shall record the name and vote totals of a write-in candidate who has filed in accordance with section 2370 of this total in the primary election and in accordance with subsection 2472B of this title for the general election. And before moving on, I'd just like to quickly note that I may have introduced some ambiguity into the idea of whether votes are counted or not. I would certainly defer to Director Senning to talk about the mechanics of it's counted.
Yeah, I want to know this recorded versus counted is interesting. Representative Hango, a clarifying question?
I think that's what I was asking first. Quickly, what is a generic write-in vote? Just anybody writes in a name, whether the person has filed a consent form or not?
Although that term is not explicitly defined in statute, I believe it's a term of art used by clerks, and I'll defer to Director Senning to provide you a more rich answer to that.
So when we take the language in section 13, what we're talking about here is mechanically creating this new thing of a writing consent that doesn't exist currently.
It would require them to file a similar consent of candidacy form, the next section, subsection B, which I've yet to get to, states that the Secretary of State shall prepare and furnish forms for candidate consent purposes. So Secretary of State's office would provide the form, and then like a candidate who had previously registered, in order to succeed as a write-in candidate, you would have to follow similar procedures. Then at the top of page 10, new subdivision 3, here reads on line 1, the election officials counting ballots and tallying results shall only list the names and votes received of those write-in candidates who consented to candidacy for the office pursuant to section 2370 of this title. Section 14 modifies Title 17 VSA, Section 2682A, and this is a subchapter that pertains to local elections, ballot system, and this is for write-in candidates, is the name of this section. Subsection A is added as well as B in front of existing, or prior to existing statutory language that exists already. Starting in line 8, A reads, in order to have votes recorded for a write-in candidate under section 2587 of this title, not later than the closing of the polls on the day of the election, a write-in candidate for any office shall file with the presiding officer a written request to have the candidate's votes recorded. And B1, and line 12 reads, a write-in candidate shall not qualify as winner unless the candidate has complied with subsection A of this section.
Representative Hooper has a question.
So in the case of somebody that, I get a group together and we decide we're going to nominate and elect Mike for something. Mike doesn't know about it. Mike gets a majority of the votes of the citizens. This basically says that their will shall be excluded. If Mike doesn't rush in and file a form to say, I didn't know about it, but I still don't know about it, but I'm filing a form just in case.
Right, the person nominated in that hypothetical would have to consent to accepting the office, I believe. Yeah, so far as the will that's being ignored is that of the voters who wrote in.
Yeah.
I guess, I don't know if it's ignored, but really their wish wouldn't be able to be fulfilled unless that candidate said, yes, I'm willing to run for that office.
It would require that group to get that candidate to consent and file
So you can't.
no later than the second Friday
Oh,
before
yeah, I
the
understand what it is. I'm
election.
basically saying, on one hand, you have the will of the people, on the other hand, you have an administrative. As it is now, if that situation evolved, I assume the representative from down south would say, nah, I refuse, or I resign, or something, but
We'll definitely welcome a debate about whether it makes sense to allow people who are unaware that they are a candidate for office to be in and elected, but.
Perhaps actually put into an office that they were unaware of that they were even in contention for.
Yeah, I think we should have we should have that conversation because that is the law today.
Yeah, no.
Representative Hooper's not wrong. That's
You'll
the
get
law today.
blindsided. Yeah.
many people that I think would make a good dog catcher. So.
Yeah. You're like, what do you mean I'm a lister?
Representative Hank.
Can't spell it.
So how in section 14, small letter A, how does that differ where it says not later than the closing of the polls on the day of the election? How does that differ from the second Friday before?
I believe it's the level of elections, so this pertains to local elections. I can't really speak to the policy reasoning for opting for this. However, I think it is distinguished from those other offices.
That would be.
So 2587 is the local election?
Let's see here. So section
I
14.
don't see any indication that that's just in a local election.
Sorry, and the way we format these, we leave a lot of the title, chapter, and subchapters out.
I know.
I apologize for kind of
Yeah, I would say
listing
Tim,
the statutory context in which these exist.
if we see another draft, if we could get some rigorous headers.
Sure.
And I know there's been
Agreed.
a little bit of back and forth about that with drafting operations. So that would help, I think, just to clarify. But am I reading this correctly that for primaries, the August primaries and general elections, both candidates who want to have the right of votes counted have to file a consent 2 Fridays prior.
Yes,
But for a local election, they just have to file before the close of the polls.
that's how I understand it.
Okay. Representative Chase.
And just to clarify, what is 17 VSA 2682A is referring to local elections using the Australian ballot system.
Yes.
So a person who's a candidate for a local office that is having a meeting where the business is being conducted at an annual meeting from the floor wouldn't have to file because there's no Australian ballot.
If they haven't opted into it. I haven't thought about that circumstance.
I would say
Sure, not done.
want to make sure that we haven't precluded that possibility inadvertently if we proceed with this.
That. And any other questions for that section?
Please continue.
Okay. Section 15 amends Title 17 VSA 2702. And this is in the chapter 57 of Title 17 for presidential elections, a subchapter for presidential primaries in particular. And this is, the section has to do with the nominating petition. New subsection F is added to read, starting on line 19, in order to have votes counted for a write-in candidate under section 2587 of this title, not later than 5 p.m. on the second Friday preceding the primary election, a write-in candidate for nomination by any major political party shall file with the Secretary of State a form consenting to candidacy for office as set forth in subsection 2361B of this title. The Secretary of State shall notify the town clerks of any filing made in accordance with the subsection no later than the Friday before the election. And again, this pertains to presidential primaries.
So we did
Exclusively to the.
primary elections, general, local in the previous sections. Section 15 is just about the presidential primaries.
Yes.
Hold my comment because it is, yeah, I think, well, the clerks, I believe, have to report every single name that's written in. So the Donald Duck, there's a very long list, especially with presidential primaries of names. Yes, especially presidential primaries. So this would hopefully solve that problem if we find it acceptable. Effective date is July.
First 2023, close down.
All right. Tim, thank you very much for that walkthrough.
You're very welcome.
Two is bring elections division director Senning up next, and we'll take a break and continue. And I know I would like to hear from Carol Dawes as well. So, well, do you want to come in now, and then we'll take a break in 25 minutes. And I think we may not quite get through all of your testimony, but if that works for you, I think we should keep our discussion going.
Excuse me. Thanks, Tim.
Thanks for being here.
Particular way you want me to proceed? You want me to answer questions? Since I've got limited time, I want to be as useful to you as possible.
I think it might make sense to have you share, if you have general specific pieces that the Secretary of State's office is supporting, and then we can talk about those sections that you wanted to highlight. Does that?
That works. Also, you know, I was obviously listening and taking some notes as we went along. If I could be helpful clarifying some aspects of the bill throughout, I'll try and do that also.
Yeah.
Will Senning, Director of Elections, for the record, from the Secretary of State's office. I guess in general, what I would say, Mr. Chair, is we support everything in the bill. We did not propose or put forth actually much of what is in this bill, to be honest, but have given our reaction and assent to being able to administer the changes that are included in the bill. Really, particularly, we supported, and for the most part, although it's helpful to our processes as well, but we really strongly supported the write-in provisions on behalf of and in concert with the clerks. As you noted, it's something that's been proposed multiple years, over the course of multiple years recently, and has never been passed. And most of the language that you see in that write-in section, although it's expanded, it comes from a previous version of a proposal to address that issue. And also, I took a quick look when you guys mentioned the number at H149, and mirrors that to some extent with some changes and some additions to make sure all the bases are covered. So I can get to that when we get to that, but we definitely support that provision. Like I said, especially in reflecting our support of the clerks and not having to deal with that issue going forward. And I'll explain that in more detail. All of the provisions related to nominations, dual nominations, party nominations, independent candidates, we are agnostic on as a policy matter and is entirely up to you all as a policy matter. I'm here to say we can implement them as they're written and try to make sense of them for you as well. Same, I would say, goes for the collection of demographic data. did not come from us as a policy proposal, but happy to facilitate the collection of that data and the presentation of it to the public as the committee's legislature sees fit. With that said, can I walk through a couple of the specifics to try and help with some clarity?
Yeah, if you could just name the section and I'll try to help direct people to where the language is.
Sure. Well, let's start at the top, right at the beginning, because I want to make sure you're totally clear on what this provision is doing. I think you got down to it pretty closely by the end of the last comments made. This only affects a candidate who loses in a major party primary, right? And says that they cannot then be nominated by another party other than the one that they appeared on the ballot for in the primary and lost. So file your petition in the Democratic primary. You lose that primary to somebody else. You can't then be nominated to that same office by the party committee of another party, either the Republicans or the Progressives. If you were to win that Democratic primary, you could still be nominated by another party's committee. And that's where there's interplay between provisions of this bill. You would be able to list both of those parties on the general election ballot and choose which order they appeared in, as you can currently, unless you implement the following sections that don't allow those dual nominations. You could still be in a case where you win a primary in one party and you get nominated by another party's committee and list both of those unless you go forward with the lack of dual nominations. What it prevents, again, is just a loser in a party primary from then being nominated for that same office by another party's committee.
Those comments only pertain to section 1.
Right. Similarly, and this is a change too, so the second section, as the chair pointed out, then essentially does the same thing with regard to independent candidates. So again, current status, right? Regardless, and then we have the filing deadline move, which is just a filing deadline move and doesn't affect any of the substance, these other provisions. Currently, you can file a petition to run as an independent candidate, and you can also appear on a major party primary ballot. If you win the major party primary ballot, you have to choose. You can't, it's current law right now, you guys know this, that you can't appear as a party and an independent on the general election ballot. The most common example of this, of course, is our Senator Sanders, who multiple election cycles in a row runs in the Democratic primary, wins that primary, also files a petition to run as an independent in the general election. And he essentially declines the nomination of the Democratic Party that he wins via the primary, being a candidate on that ballot, and then runs as an independent candidate instead. This provision wouldn't preclude him or anyone else from still doing that. You can still file both. You file your primary petition, file your independent candidate petition. Now with the filing deadline, you'd have to do that at the same time. Right now you can file for the primary and kind of see how that primary is going through the summer and decide whether you want to file an independent petition anytime up to 3 days before the primary. This says you basically got to put both of those in at the same time if you want to be covered in both of those bases. If you win again, you have to choose between the two. What this says is that if you lose the major party primary, you couldn't then take up your independent petition. So essentially in our office, you lose that major party primary, that petition is just no longer viable, right? You filed it back when you filed the primary petition, but since you lost, this provision tells me I'm not putting you on the ballot as an independent. So if Bernie were to lose the Democratic primary in a Senate run like he does, he then couldn't follow up and run as an independent.
So he has to, a candidate like that hypothetical has to win the major party nomination they filed in order to then decline that and appear as an independent.
Correct.
Not the inverse.
Before we move on, Representative Waters Evans.
I'm just getting a little confused because there are so many different sections. This sore loser law, does that apply only to state and federal elections, or does it also apply to local elections?
State and federal.
Okay.
Yep.
There are no, but that's because there are no party primaries for local elections.
Correct.
Okay, just, thank you.
And generally no party affiliations in local elections, with the
Okay.
exception of Justice of the Peace.
On this particular piece, and I know this may have been 8 years ago, I'm sure Director Sending can remember better than I, but this has been talked about for a long time. And I know that we didn't pass it a number of years ago. And I guess I just would like to certainly hear from maybe independent candidates or whatever in regards to this particular.
Yeah, duly noted, and we absolutely.
I don't want to go too far down the hole, but that, it's interesting because the sore loser name tag in the past has been used to talk about the independent candidate filing deadline. And what you may be thinking of, Rep. Higley, is there once was a day when the independent filing deadline was actually after the primary. So you could straight up wait, not do anything, see if you won or lost the primary, and then file as an independent. That you still, under current law, if you guys did nothing, that's still not on the table. You have to file that independent candidate petition first. But since you could still activate it, if you lose that primary, even having had to file it earlier, this precludes that option.
So
The bet hedging.
two clarifying questions. These provisions that are in this draft language before us, they would allow somebody, as you said, to file a major party petition and an independent petition. But if they lose a major party, they can't run as an independent.
Yes.
Just the filing deadline piece. Under current law, a major party candidate files in May.
By the end of May.
How late can someone wait that's considering to file as an independent under current law?
It's the Thursday before the primary.
Thursday before the primary. So we're into late July, early August.
Yes.
Representative Hango.
So in this case, if this were to pass, why would anybody file for a major party and an independent at the same time in May, knowing that if they lose the major party, they can't run as an independent anyway? Am I missing something here?
It's the the director sending. Need more coffee this morning. Gabe was Senator Sanders.
Yeah.
So he prefers to be on the ballot as an independent. He caucuses with the Democrats. He wants the Democratic nomination. He has sought that for several election cycles. But in this instance, if he wants to be an independent on the ballot, he would have to file both and win the major party nomination, then decline it and use the independent. But if he lost the major party nomination, he wouldn't be able to be on the ballot at all. So if he wants to be an independent on the ballot and also sort of get the nod of a major party, that candidate has to file both in order to do that. It is an unusual thing. I don't know of too many folks who are doing that, but around the country, there are some examples, the senator from Maine, senator from Vermont. But that's really the only instance.
This is really like person specific, candidate specific.
It's actually, I would say that the functional thing about this and it is more about any candidate having to choose which path they're taking as opposed to filing, to try to hedge. This is about, for me, and the reason I'm supporting putting this language up for discussion, it's about the integrity of what it means to run with a major party. If you're truly running as an independent candidate, the ballot access is open to you and you should do that. And if you're running as a major party candidate, but this thing of being able to kind of see which way the wind is blowing and then file late as an independent candidate, that to me reduces the integrity of what it means to be a major party candidate.
And I get that, but if you truly want to run as an independent, then if you lose the nomination for a major party and can't run as an independent, yeah, I guess I see where you're going, but I don't know. I don't like pigeonholing people into parties.
I think that this does the opposite, but we'll have time for debate. I want to get to Director Sinning's comments and clarifying questions. So I saw Representative Boyd. You're good. Representative Chase?
Yeah, I think what I'm hearing is that if you want to be an independent candidate, you just file the independent candidate form and you don't have to do anything with the parties.
So this is very specific then to people who want to file the independent and another major, and a major party. So it is very candidate specific that we're aiming this at.
No, I would say that this happens pretty frequently, that there's the potential for folks to try to be multiple parties and to use the cross nominations to stay on the ballot even when they lose. So
I guess,
we'll bring
hearing
people in
from
and talk about a
independents
number of
would be
examples.
important.
Representative Nugent.
Am I right in thinking that this assumes the intent of the person who runs as a major party, but then assumes that their intent was to spoil the election potentially, not that they just changed their mind and decided to run as an independent?
That'd be a question for the folks who are proposing the change. But it would have that effect.
Yeah, we'll definitely dive into that, but that's, generally, yes, that's the intent.
Independent candidate filing deadline is pretty straightforward, moving it from the Thursday before the primary to the same day as the deadline for you all. I mentioned it briefly when I was doing the overview the other day. This would, in the past, I said to Rep. Hillby, at one point it was after the primary. The first move after that point was to this same date. So it did exist as the same deadline as you all have for your primary petitions for a certain amount of time, was challenged in court. Tredell is the name of the case, if anybody wants to look at it, and I can send it around. But the court upheld the deadline at that point, as it is here and as it was then, at the same time as you all. Even though the court upheld the deadline, the legislature went ahead and moved it to the Thursday before the primary. And I believe, I don't want to stress my memory too much, but it was mostly a discussion of convenience and allowing for somebody to decide to run as an independent between May and late July. Everybody, I think at that time in the legislature, everyone who voted for it clearly still wanted it to be before the primary so that there wasn't that sore loser aspect of it. But they decided to give independent candidates 3 more months to make their decision. And at this point, you're saying everybody chooses what they're doing, as the chair said, at the end of May at the same time. The next section, on the campaign finance limits, I am not an expert in the federal campaign finance law. I have to pick my battles in terms of what area of the law I become an expert in, because I have so much to cover already. But I am told that, as the chair said, that federal candidates can make unlimited contributions to our state parties. And currently, statewide candidates are subject to the limit up the crossed out big A, the $10,000 from a single source. A single source, if there's no other language in there, applies to a candidate. And so right now, the party can only accept up to $10,000 from candidates statewide and down. I'm told that they can accept unlimited contributions from federal candidates, and that the goal here is to make those the same so that our statewide candidates can also give unlimited contributions to the state party. And I would encourage you to, bring in the folks who are asking for this.
We'll put a pin in this, but I will just tell you that limitation of a statewide candidate for a major party only being able to contribute $10,000 to their political party creates some very perverse things with the trying to get coordination between statewide candidates, and that hard limitation is interesting. You know, if you think about like just a software license to use a platform from a major party can be in excess of $10,000. And so, you know, does a statewide candidate buying the major parties, you know, preferred software vendor's license constitute the single source? And then, I mean, this cap creates some weird stuff that we're going to hear from. So we'll put a pin in it for now, but I just wanted to say that on its face, you're like unlimited contributions, but there's a method behind that actually I think promotes transparency. Representative Chase.
I'd like to get a little more explanation maybe later on a political party shall not accept contributions from a political party. Like that seems like my favorite phrase is a self-licking ice cream cone, but that seems a little weird. But
political parties do work together sometimes on elections.
I think just really quickly, I think that also applies to situations where it's different levels of committees. So the state committee can give to a county committee,
Gotcha.
county to state, party that's party to party.
Yeah, so under state law, a county committee is a party as well as the state committee is a party.
Section 5. I want to be quick again with the limited time and so we can get to the write-in stuff. The quick history here. So what this said, the history is the easiest way to explain this. As the chair said, it's the only place where our office and the law, state law, Title 17, the election law, really touches political parties. As Representative Hooper pointed out, it's a general matter. The way they function and the way they operate is in accordance with their bylaws and is not regulated by our laws. The exception to that is the organization process every 2 years. And the state law, Title 17, lays out some parameters for that organization process. When the town caucuses have to happen, the form of the notice for those caucuses, how many people, the offices they have to elect. Same thing for the county, which happens about a month later. It lays out that time and that process that you guys go through. And then, the state committee is the last step. 2 iterations of the law ago, our office used to receive all of the paperwork from all of the various town committee, town and county committees as they organized, including copies of the notice that was posted and then membership lists, who were the officers, et cetera. Our office would house all of that and get it from all of the various individual sources and then be responsible for providing it to people who asked for that information. We worked with the parties a couple years ago, it was either 2 or 4 years ago, to essentially streamline that for us. And it's been really, really successful for our office as is the way I would put it. Essentially, instead of those town and county committees sending their paperwork to us, we directed them to send it up to the state committee of their own party. Then when the state committee organized, part of, I think, the idea behind us getting the paperwork to begin with was for the few places in the law where I mentioned it requires that you organize in 30 towns across a certain number of counties. The implication was that we were doing that analysis and making sure that you had met those thresholds as the organization process went through. So we changed it to say file with the state party. They make the assessment of whether they've met the minimums that are required. And then we essentially turned it into a statement when they file their state certificate of organization that says we've organized in the following counties and towns. We've met the threshold. We're all good. But the information about the membership on those committees is currently housed by the state parties. An unintended consequence, I think, of that is, of course, that information, all of the information about who were on these various committees at various levels for the parties was no longer public information. Since it's filed with the state committee, they're not obligated to share it with anybody. So I believe the intent here is to, again, make that information public and accessible from our office. And in discussions with the parties, we decided that what would be easiest, we didn't want to go all the way back to us accepting all of the paperwork from all of the various town and county committees. So instead it flows up to the state party. And when they file their certificate of organization with us at the end of the process, they just give us a single document, as this says here, with all of the information for their county and town committee members, so that somebody can come to our office and say, can you tell me who's on the Orange County Democratic Committee? And we can provide that information.
Just wanted to give you a heads up because I think there's a couple more sections before we get to this.
Yep.
But I wanted to do something a little unusual. And before we dive back into the write-in pieces, I'll have Representative Brennan come up and talk about H-149 so we can both his comments and ideas that might be a little different than our write-in language.
Sure. Whatever you'd like. Does it go right to, yes, it does. So the next section, section 6, dual nominations. This says that a person can only have one party listed by their name on the general election ballot. Tells them that they have to let us know which party they would like by 10 days after the primary, which at this point is the same time when they just have to tell us the order that they would like, if they may have gotten nominated by more than one committee. And as was pointed out also, it says if they don't notify our office of which party they would like, we're going to default to the one in which they were printed on the ballot. And it does go to exactly the scenario that the chair pointed out, which would be that you appear on one major party's ballot by your petition, but then you get enough write-in votes from another party to qualify for that office. You then should and do have the option to choose which of those two you want. But if you get around to telling our office by 10 days after the primary, that never happens. We always hear from people about what order they want their parties in, or whether they're declining a nomination or not. I can't think of a time, an instance when we had to default to what this, all of the stricken through language is if dual nominations are allowed, of course, then we have to think about, we have to have some direction to us in the law about what order to put those in. And that's what was written here and is stricken out in the case that you're not allowing dual nominations. We're not in that position anymore. And it becomes more simple to just say we are going to use the party that you were on the primary ballot for. I recall some of the questions that were going around during your discussion of these dual nominations. Really quickly, number one, before Representative Waters Evans had pointed it out, I had remove also in my notes for that reference to the town clerk. We saw that just yesterday. And the deal there is that we have all of the information at this point for candidates going on the general election ballot. There's no point in them telling the town clerk. They need to tell our office at that point. So we removed town clerk from that language. Again, I'm trying to remember some of the questions that came up, but as the chair pointed out, we will have plenty of time.
Yeah, and I think one of the biggest things with this was just the idea of what's the order of operation. So if we decided to go down this road and somebody was written in under another major party, so they had 1-2 nominations, what happens then? And your understanding, I think, is the same as mine, that the candidate would get to choose which party's nomination they would have printed if we were only allowing one, but that if they didn't choose, then the party they filed under originally would be the default. We got there. It was a little convoluted, but we got there.
Then moving on, if we don't have questions right now on that one. Section 8, I can quickly touch on, which is the demographic information. I want to point out just, so the first section that is addressed with this demographic collection is for, is in the nomination chapter for the primary. So it applies to all of you from state rep up through the statewide offices. This is when you're filing your petitions with the rep district clerk or the Senate district clerk or our office for statewide candidates. And so it's just when you're filing that consent form along with your petitions, it's collecting this additional demographic information. It makes really clear that you do not have to provide it in order for your name to appear on the ballot, which was important to us to just be able to clearly answer that question for folks. And you all know that after that paperwork gets filed with our office, this is something we can discuss and talk about what your preference is here. Our office then posts a list of candidate listing for the primary. And we provide on that listing all the information that you all provide on your consent forms. It's highly sought after information to be able to reach out to you all by citizens and interest groups alike. And so as this is currently written, I just envisioned an additional 3 columns on that spreadsheet indicating the answers to these questions by the candidates. So you'll get the candidate name and the demographic information. I hadn't heard discussion about whether we do or do not want to provide that information for individual candidates like that, whether we only want it to be aggregated. That's going to take a dive into the public records law, because once you provide this information to my office, it's public if somebody demands it, and I need to have a legal reason why I can't provide it. So that would be a project for Ledge Council to look into, I believe, if there's concern about that.
Yeah, I think we're not moving so fast that I think there's a need to send him on a wild goose chase at this point. So I would say at this point, your understanding is if we do move forward with having this data be on the forms, then the candidates would need to understand that data, their self-declared identifying demographic data would be made public. And if they didn't want it made public, they just would need to omit that data on the form. That would be the default, right? That it would be public.
And if there either is already or there were to be created an exemption in the public record law for it, that would mean we can only provide it in an aggregated form. I would want to and need to think further about whether the responsibility for aggregating that data is something our office wants to be responsible for on an ongoing basis.
But to be clear, your office is comfortable with the language as it's presented here because you're just collecting it and making it available.
Yep.
Thank you.
The second, section 9 is, make sure, that's just the consent form itself where it's referred to. And so we wanted to make sure that this was referenced there also. And then section 10 is local elections. That's right. And what I want to make clear here is that, as you can see, the current language, what's stricken through there, struck through, excuse me. The town clerks are currently required to provide us a listing of their select board members, and we post that on our website. If you look on the local elections part of my website, there's a spreadsheet right now with the names and addresses of all the select board members across the state. We currently are required to collect select board members and justice of the peace candidates. So we have listings for both of those. That seemed like the appropriate place to collect and present this demographic information for local candidates, which the people interested in this also wanted to be able to collect. And so when the clerks continue to report to us, and we collect it after town meeting, so everybody's elected annual meetings, late March, early April, we send around a survey to the clerks to collect the information about their select board members. And again, I envision this just to be another 3 or 4 columns on that spreadsheet for the select board members. And they did add, to be clear, city councils, village trustees, and mayors are also included. I wanted to look back at our list before I came in. I didn't get a chance. I think as a matter of practice, we get those mostly from the towns that have a council instead of a select board. They send us that information even now. This makes that more clear. And then just says that we'll collect and present that same demographic data. when discussing this with Carol, she wanted to be really clear, and I think it was a good idea that we have an affirmative statement that the clerk isn't required to ask the candidate for the information and follow up. So really specifically, it's clear it's not required, but if the clerk gets the consent form, sees that those fields are empty, they're not responsible for following up with the candidate and saying, hey, don't you want to tell me your gender and age and the other pieces that are asked for here. So we're comfortable with those two provisions also, but we should think about and address the aggregation versus not disclosure of the information.
Okay.
So for write-in candidates, it's right. This is the biggest change in the administration of elections that's contained in the bill. It's something that clerks have advocated for many years now. I'll let Carol touch on that piece. Under current law, I'll point you to, so, and the way this is structured, it's a little difficult without the whole body of the law to look at, right, with the way these bills are. There's 3 different sections here about the requirement to file the paperwork. And as the chair pointed out, it's for the primary election, then the general election, and local elections. 4 then, primary, general, local, and presidential primary. Then the 2587 that's referred to in kind of each of these where the filing is required, you'll see. Section 11 is in order to have them recorded under 2587. That's a general rule in the conduct of elections chapter about how you count votes.
Okay. So what I'd like to do, if it's okay with you, Will, if you have time to stick around, is to invite Representative Brennan to come up and talk about H-149, which I think has very significant overlap with this language. And I'd like to get his perspective and take and see if there are best of both worlds or if we should kind of go in one direction or the other. But I think just at this point, I might have you all switch. We'll take a brief break and then we'll come back and dive in. And I really appreciate Carol's patience while we have this expansive conversation about this. And we'll have her in after the break as well. But thanks, Carol. Really, really appreciate you being with us this morning. Representative Brennan, please tell us a little bit about H-149, and this is available, the as introduced version, which just came across at the perfect time, Representative Brennan.
Hot off the press. For the record, Pat Brennan, representative from Colchester. And I was hoping to hear a little bit more of that bill. I thought he was going to do all my work for me. But what my bill does, it's a result, I should tell you, of a conversation with my town clerk, a hallway conversation where I asked her, what can I do for you this year? Any wishes, any wants? And this was it. So basically, I won't say it's simple, but it's what it does is require a write-in candidate to file a consent form to be a write-in candidate, excuse me. So that when the town clerk does count write-ins, it's quite an onerous procedure. Time consuming, takes 2 people. So her idea in consultation with the Ledge Council was to have the candidate in the primary, in the general, and in local elections file a consent form with the Secretary of State in the case of the primary and general, no later than 5 p.m. on the second Friday preceding that election. Same for the any local election, you have to file with the municipal clerk. So that's the crux of the whole conversation. And I can tell you, I'll read you a little excerpt from my town clerk. First, hand counting and listing each write-in name with a team of at least 2 election officials on election night. Second is completing official reporting within the Vermont Election Management System. This entails entering every name into the software with related number of votes. The majority of these write-in names only receive one vote. And she goes on, but that is the general concept of the bill. She also, for Colchester anyway, in the August election, we had 324 names just in Colchester that had to be manually with two people entered into the system.
24 separate, distinct individual names.
Yes, separate distinctive names, and then another 428 in the general. So she said she spent more time doing those 428 than the whole rest of the election tabulations. In this bill does the same section of law, I believe it. Yeah, 2587.
So Representative Brennan, thank you so much for coming in. I did not know this bill was coming to us. And some folks from the various clerks had a desire to have something like this. And so I had included a version of some of this. I think one of the key differences, as I'm reading it right, in the language that we were just looking at, the sections of our kind of, I don't know, I don't like to use the word omnibus, but you know, our committee elections package that I put on the table this morning for the first time. It does the 5 p.m. Deadline two Fridays previous to the election for the primaries, the generals, and the presidential primary. But for the municipal elections, it makes it just that you have to file your write-in by the close of the polls on election day. So it has that one, that one difference, I think, from your language, if I'm reading.
Yeah, I don't necessarily think the 5 days for the local elections was a request of hers. I think it's a drafting thing, and I'm sure she'd be open to anything, you know, that makes it better for her. I don't think it has to be 2 Fridays before the local election.
Oh, okay. Yep. All right.
I mean, it is that in the bill, but I don't think she's married to that.
That's what we have on ours for the three other big elections, but the local elections by Australian ballot, we were thinking about letting it be closer to the to the day.
Sure, I'd be amenable to that.
It's clearly an idea that is in the clerks, Vermont clerks universe. Yes, Representative Chase.
Not for Pat, but for anybody else in the room, do clerks start counting before 5 p.m. ever?
So my understanding is so we should talk to Director Senning about this when he comes back after our break about the order of operations. But there's the consent form coming in 5 p.m. is different than the close of the polls that's in our local language. So I think we might want to ask Will about those distinctions. But this is very timely, Representative Brennan. I appreciate you.
I got lucky.
Giving us the local clerk's perspective. Thank you so much for being with us. So what I'd like to do now is give the committee a 10-minute break because it's been going for a while. Come back and hear from Carol Dawes and then wrap up with Will. And that'll get us